Good morning. Welcome everyone to the April 7th, 2014 meeting of the Tennessee Real Estate Appraiser Commission. Notice of this meeting was posted to the Real Estate Appraiser Commission website on March the 20th, 2014. We are meeting at 500 James Robertson Parkway in Nashville, Tennessee. And we will begin with the call to order. So beginning at my right, please announce your name and where you're from.
Tim Walton, Collierville, Tennessee.
Eric Collinsworth, Arrington, Tennessee.
Michael Green, Johnson City.
Norman Hall, Brentwood.
Gary Standifer, Franklin.
Excellent. I note that we have a quorum this morning. Thank you, gentlemen, for appearing this morning. First item on the agenda would be to adopt the agenda. Is there a motion to adopt?
So move.
Second.
Motion by Commissioner Hall, second by Commissioner Walton. Any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes. Very good, thank you. So we have adopted the agenda. The next item is to review and approve the March Commission meeting minutes. If everyone's had a chance to review those, are there any corrections or additions?
So moved, be approved.
I'll second.
Motion by Commissioner Hall, second by Commissioner Collinsworth. Is there any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? Motion passes. The March minutes are approved. Next item on our agenda is the education report. And we had four interviews that were conducted this morning, to my knowledge. The first item is by Commissioner Collinsworth, who interviewed Marquez
Morris.
Marquez Morris, and he was going for a license to certified residential. Mr. Collinsworth?
Yes, I interviewed Mr. Morris this morning, and he is moving from licensed certified residential. He has already taken and passed the exam, and after our interview, good discussion with Mr. Morris, it is my suggestion that the committee move to approve and vote to approve to allow him to move on to certified residential.
Thank you, sir. So your recommendation is to approve. Is there a motion?
Motion to accept Commissioner Collinsworth's recommendation.
Second.
We have a motion to accept by Commissioner Walton, a second by Commissioner Hall. Is there any other comments? Hearing none. All those in favor say aye.
Aye.
Any opposed? None opposed. Motion passes. I had the next interview. I interviewed Shane McAlexander, and he was going for trainee to certified general. I'll turn over the meeting at this point to our former chair, Commissioner Hall, for his conduct.
Thank you, Chairman Green.
I do. I found Mr. McAlexander's work to be very proficient. He has not yet taken the exam, so my recommendation would be to approve the upgrade from trainee to certified general upon his passing the exam.
We've heard recommendation. Do I hear a motion?
Motion that we accept Commissioner Green's recommendation.
I have a recommendation from Mr. Walton. Do I hear a second?
I'll second.
Second from Mr. Collinsworth. Discussion. Hearing none, all in favor say aye.
Aye.
Opposed, like sign. Motion carries. Turn the chair back over.
Thank you, sir. Commissioner Hall interviewed Roger Stacy this morning, and he was asking for an upgrade from trainee to certified general, and he has not taken the exam yet. Commissioner Hall?
I interviewed Roger Stacy this morning, and it's my recommendation that
For the recommendation, do we have a motion?
So moved.
Motion by Commissioner Collinsworth. Is there a second?
Second.
I have a second from Commissioner Walton. Any discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes. All right, our last interview was by Commissioner Gary Standifer, and he interviewed David Cates, who was asking for an upgrade from trainee to certified general and has not yet taken the exam. Commissioner Standifer?
I reviewed this individual. His work was at a level that warranted my recommendation of approval.
Okay, very good, thank you. Is there a motion?
So moved.
All right.
Second.
Motion from Commissioner Collinsworth, second from Commissioner Hall. Is there any discussion? Hearing none, all in favor say aye.
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 None opposed, so the motion passes. Excellent, thank you, gentlemen. Next item on the report is the education report. Sorry, y'all, taking these out of order here. The education report, that's conducted by our very competent director, Ms. Avers.
Yes, there's 4 courses on the education report, 3 from the Appraisal Institute, application and interpretation of linear regression, residential applications using technology, residential applications 2, and there's 1 course from the International Right-of-Way Association, which is understanding today's regulatory environment. Recommend approval for all of those. We have an individual course approval for Lonnie Satterley and 1 for Paul Meredith. Each of them took courses that weren't previously approved. However, the courses I would recommend for approval for 7 hours each. Mr. Collinsworth also looked over the second one for consideration because that one was just wanted a second opinion on that one. And instructor approval, these are already approved courses. They're just adding an additional instructor for these courses, which is Mr. Humphreys. And I'd recommend approval of that.
A question for you, Ms. Avers. Under individual course approval, I see the 2014-15 USPEP 7-hour update. Is there, okay, so it's been added. All right. Thank you. So you haven't talked about the IRWA course for the Education Committee report. You want to, since we don't, I assume that Commissioner Collinsworth will recuse, which means we don't have a quorum, which means that we need to bring this up at a later time, or?
You have quorum, you just don't have enough to break a tie. He's still here to hold quorum. As long as you get at least 3 of you to approve it, then it passes.
I'll just need to abstain from voting on that.
Sure. I see, okay. Well, you haven't talked about that. Did you want to address that? Do you recommend for approval there?
Yes, that is course 1743. I recommend for 4 hours of continuing education approval.
All right, so that's the entire education report, is it not? Okay. Do I hear a motion?
Motion to accept.
All right, is there a second?
Second.
All right, motion by Commissioner Hall to accept, a second by Commissioner Walton. Is there any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? None opposed, so motion passes.
Mr. Chairman, may I ask a question?
Yes, sir.
Nicole, have you heard anything more about us getting some?
There's another candidate that's being considered by the governor's office, but I haven't received any papers. Know what I know.
About?
Also, to help Mr. Green a little bit, I noticed about him asking the question about the IRWA course.
Thank you. That's excellent. Thank you. Yeah. I found that I absorb knowledge much better in that environment. So that's excellent. Yeah. It will certainly help me to understand today's regulatory environment more,
No question about it.
I think. Yeah. Excellent. Thank you. Thank you. My sage advisor. Yes. All right. Next item on the agenda is our esteemed director's report. She's about to tell us how much she knows, I'm afraid.
And it's going to be a very brief discussion. On the director's report in your agenda, or on your iPads, if you would just turn to page.
Possibly.
13. That is, right at the top is the most updated information I had on the two bills that we're moving through. Senate Bill 1620, which has a companion bill, House Bill 1416. That is for initial applicants for registration, licensure, or certification will have to have fingerprint background check. That has been passed and went through, has been signed by the Speaker and the House. It's waiting for the governor's signature on that one. And Senate Bill 2081, that's the removal of that 30-day prior to expiration date charge for being late. That one has fully passed and is actually implemented. So officially now, applicants or licensees are only late if they are past their expiration date. So that's good.
Question for you.
Yes.
On the background check, on the first bill, will we have to have rules that, so this isn't all of it, we will still have to pass rules?
Yes.
Okay, thank
Which
you.
will more specifically
Thank you.
say how we do that.
Yeah.
On the next page, there is a pending piece of legislation, national legislation, which is Senate Bill 947 with the 113th Congress, first session. This is to include additional language, which will be or financial services before industry. This would allow appraisers to be under the same law that mortgage brokers are in the SAFE Act, and therefore we could use the National Mortgage Licensing System to do background checks, which would mean that that information would be shared in every state if the state subscribes to that system. Before, we really couldn't get access to the NMLS, but with this, if this law passes, then we'll be able to use that system instead of having to create our own. So that will be
Would be nice.
helpful, yes.
Yeah.
And you get one background check for a series of states as opposed to having to have it done and done and done, so.
Commissioner Hall, that was kind of a hot button with you.
As long as we can,
There will be additional discussion at the Aero Convention on this specific topic. We're having two speakers come and talk about that. The Tim Doyle from the NMLS and director from Texas, Doug Oldmixon, is going to talk about it. And then John Brennan from the foundation is going to talk about the change to the AQB exposure draft. So there's going to be a lot of good updates. So Keeling and Mr. Green and I will give you an update at the next month's meeting on how that went. Or I will.
questions. This basically says that we will all reciprocate then on the background checks and fingerprints.
Well, we'd have the ability to. States don't have to subscribe to the NMLS. They could do it independently on their own if they chose to. However, I think that public opinion would probably sway towards, why don't we have one system so that you all can use the same information, as opposed to me paying for it, a background check in Georgia and a background check in North Carolina and a background check in Tennessee.
Will this still be app?
If you have more than one type of credential and it falls under that SAFE Act allowance, and yeah, then that information could be linked together. You essentially just add a different kind of application to that system. So it has the ability to handle more than one type.
Oh, do you know if the sales people in Tennessee are going to use the mortgage system?
They are not covered under
Safe?
the SAFE Act currently, but they might be able to in a future
I was just curious.
reiteration.
Like-
Right now, they're really trying to incorporate us into it, the appraisers. So
Step at a time.
They don't require right now a background check or fingerprints and the that nature, do they?
our initial, and if you let your license expire and you want it back, yeah.
We just passed it.
I just want to, because I'll have to have mine renewed, I reckon.
Actually, you'll be grandfathered. It's my understanding you'll be grandfathered, but
Oh, okay.
Once it expires.
If you let it expire, though, then you'll be subject to it. So don't let it expire unless you wanted. Fall under that.
I've had my realtor's license since 1972, so I don't think I'll probably let it expire now.
it could work out very badly if you do. I'm just kidding. All right, I'm sorry. Miss Avers, please proceed.
Okay. I'm going to come back to the rulemaking session,
Okay.
because I have a couple of items that essentially were carryovers from the last time. We've received a copy of the draft rules that the CFPB published. This would be the minimum requirements nationally for appraisal management companies. It's a quite lengthy document. I've read it, and I think Mr. Collinsworth has perused it deeply.
96 pages.
It's a dilly, and it reads like a VCR manual. And you have to pull the associated documents with it, yeah, to understand it, because they keep referencing the TILA and SAFE Act and FIREA, and so they use acronyms and letters and numbers, and the only way you can get it is if you actually print those documents out.
I found all of those references to be accurate, though.
They are accurate, yes. It just makes it a little bit harder to understand, because essentially you need a recipe for the recipe.
Right. Well.
But it does follow. I would recommend everyone read those, and if there's any language in it that causes pause or concern, that you submit comments to the CFPB on this before they become final, because once they become final, every state is going to be held to this minimum standard.
Or they won't have AMCs doing federally related transactions based on what I've read in there.
Oh, essentially, it'll be the same process as the appraisers on the National Registry. If you're not on there, the banks won't be able to use you. So we have until 2017 sometime to get this, to make sure that our laws and rules match the federal laws and rules, or meet or exceed at least.
Okay.
Next page, there's the license, the budget information, and the license status counts, which have all remained essentially the same in the last month. If there's no further questions on those two topics, we can talk about the rules changes.
Have you moved on to the 2015 rules planning discussion on our agenda?
Yeah.
Okay, thank you.
If you have no other questions about those topics.
Is there any questions from commissioners? Hearing none.
Here's where you need to use your skills at using the iPad, Mr. Standifer. If you tap your iPad once and click to page 140, you can see South Dakota's response letter to the AQB changes for 2015. Ms. Sherry Bren and their attorney, Mr. Arnold, wrote a letter in response to the AQB's proposed changes, essentially expressing frustration over them proposing an exposure draft with less than 10 months to go on the criteria. And there's also a letter from the state of Iowa. Tony Bright is their director, and they had concerns about the AQB's exposure drafts, specifically under the disqualifying criteria for background checks. At the bottom of the first paragraph, this is on page 143. The bottom of the page there, some states have used the word revoke in a looser term than the state of Iowa interprets revocation, such as not paying a renewal fee or failing to take your continuing education. They could revoke your credential for that, and that would mean that you are not able to gain a credential anywhere in the United States now for 5 years if your license has been revoked. So their recommendation was that they leave that to the state boards to determine whether or not the discipline action taken against an appraiser in another state was sufficient to disqualify them for gaining an appraisal credential in Iowa. That actually was a very sound argument, because there are times, the state of Oklahoma, for example, if you gain a credential in that state, they issue you a 3-year license, but you only have to pay for it 1 year at a time. So if you don't, 1 year goes by, if you don't pay for the next year, you have an active credential for 2 more years, but you haven't paid for it. So if you don't do it, they issue you a revocation. So just for not having paid your renewal fees. Only come in to do an assignment for a couple of days or weeks, months, whatever, and then you leave. You don't necessarily want the credential. You'd have to surrender it in order for it not to be deemed discipline. So those are just some little nuancy things with the AQB criteria. And then
So basically the state commissioners from the various states, this is still a work in progress, and is there any chance that this might get delayed from 1/1/15? Given
just the background check thing, possibly.
Yeah, given the late exposure draft request or comment request.
The exposure draft would, if it's approved, would extend out enforcement of that component of the AQB criteria till 2017. All the other portions, like the degree background check, the trainee supervisor requirement, those go in effect still in 2015, January 1st, 2015. Just the background check thing may not be enforced. We already had legislation pending. I looked at it. There wasn't anything in the bill that we proposed to Congress, to the state representatives, that would be inconsistent with the requirements, even the proposed requirements. It still would have done it. So worst case scenario, we're ahead of the game by 2 years, which is not a bad thing to be. It's really going to
Fantastic.
delay our possibility for getting dinged on enforcement from the appraisal subcommittee for 2 more years, if that section, gives us time to implement. And
Fantastic. Good.
anything, it's just going to delay it. That component, everything else we'll have to have before 2015, on or before. So,
Good.
and we're going to be audited in January.
We
by the
are.
subcommittee, so we get to be the first group to be audited on their first requirements. Yay.
Was it something we said?
It's just our normal cycle. We always have it be odd year, every other year, on the odd year in January. So we'll
Oh, man.
probably have a 3-day meeting that month.
Okay.
It would be really great if we could get our complaints knocked down to a level where all complaints were under 1 year.
Are we not there?
We are not there.
Because we don't have that many complaints this time.
The reason we're not there is we have several items that are ready for litigation.
Right?
We don't have, well, we have a litigation attorney, but Jesse stopped working here in March, and the new attorney took over the caseload for litigation. And there's several cases that this new attorney is going to have to be brought up to speed on and be prepared to litigate. That's going to take some learning curve.
Could you speak in the microphone, please?
I'm going to send the new litigator an email and ask him to come down so you guys can meet him.
Building? Okay.
Thank you, Ms. Baird.
Then on page 149 of your board documents, the new rules begin, and you have the red line version. I made the changes that you requested last month, so you can see those. Anything in red is new. There is a couple of new things in here also. On page 151, there is a fee proposed for issue of a temporary license.
Savers, could you, in the future, will you please number these pages on the hard copy?
Hard copy, sure. That
And
would be
then-
Rule 1255-01.404.
Thank you. Okay.
And you don't have them.
Okay, so the hard copy I printed before is not, oh, wait a minute.
That was a last minute add.
Doesn't have that last minute change.
Okay, so the iPad has the most current version,
Yes,
so we're back to the iPad, so, I'm sorry.
page 151.
Okay.
Oh, he's got it. Norman's got it.
Norman has the current, okay.
Mr. Hall has a current copy.
Yeah, go one more page on your iPad.
Okay, all right.
There you go.
All right, I'm with you. 151, iPad, thank you. Please proceed.
There is a law in effect currently that all of the boards have to implement a program to make an allowance for military spouse, if you're transferred to the state and your spouse is in the military and you hold a license in another state, you have to create a rule for each of the boards that allows the out-of-state person to come in and get a license on a temporary basis. Frankly, we already have the license, we have reciprocity with every state, and we have a temporary practice permit. So I don't think anyone is ever going to use this, but in keeping with the of our legislators. We now have this language proposed in the rules changes. Everything else stays the same until we get to, these are just the same things we discussed at the last meeting. The trainee supervisor course on page 165, I changed it to 7 hours per the discussion last meeting.
Discussion of.
Yes.
Yep.
There's probably, this talks about registered trainees. There's probably a companion statement about supervisory appraisers, isn't there?
Yes.
Okay.
That is on page.
Oh, 550104 again.
It's on the page that we were previously discussing, which was,
I'm trying to. what is-
152.
I saw that the F and G added, application for temporary authorizations, 4375 per 3-month increment. Authorization insurance fee, 4375 per month, 3 month.
That's that for the military spouses. You can pay for, if you don't meet, if you're not, your license isn't substantially equivalent to Tennessee, then you can pay for a temporary license. And you can have up to, I think it's 9 months, to meet whatever deficiency you have. And it's later in the rules that goes into what is required for that. And I'm going to explain it more when we get to that page. That's just the fee part, which I have to put it with all the other fees.
That's fine. I noticed it was in red, and I couldn't quite figure out why or what it was.
Because the legislation has willed it, so.
federal legislation. Oh, it's
State.
oh, it is
It's a
state, I'm
state
sorry.
law.
Yeah.
Those fees were set by the state also?
Yeah.
Okay.
Again, I really don't think anyone is ever going to use this, but, and I'll explain why when we get to that section.
Well, a lot of the stuff, when I read through it, it looked like the legislation was actually targeted more toward paramedics, EMTs, nursing, that kind of thing. But I think they kind of are painting with a wide brush to make sure that everyone's covered.
If you turn to the reciprocity section of your, I'm going to skip over the denial part.
Page number, please.
Getting there. L5506.03, and that is page 180. New section, and it's expedited licensure for certain military personnel and spouses. Applicant for licensure meeting the requirements of TCA 4311304D1 may be issued a temporary authorization upon completion of such application as may be required by the commission and accompanied by an application fee, which is the part you saw before, and temporary issuance fee if the commission determines that the applicant's license in another state does not meet the requirements for substantial equivalency, but that the applicant could perform additional acts, including but not limited to education, training, or experience in order to meet the requirements for license to be substantially equivalent. Issued in 3-month increments. In no case can it be longer than 2 years. And the temporary authorization shall expire upon the date set by the commission and shall not be subject to renewal except through completion of the requirements for substantial equivalency. Or by extension of time granted for good cause by the commission. An extension of temporary authorization shall be in 3-month increments, and then the fee for each month 75. The temporary authorization shall only be extended for good cause by 1 3-month increment at a time. No temporary authorization shall be issued to any person whose current registration, license, or certificate as a real estate appraiser is not in compliance with Title 11 FIREA as determined by the appraisal subcommittee established thereunder, or the temporary authorization shall be granted if the applicant does not hold an active license or certification in good standing. D and E is why I don't think we're ever going to get anyone using this. Because if you already hold a license or certificate in another state and are in good standing, we would grant you the 2-year credential. So parts of D and E, unless you only wanted to pay for 3 months, and that could be the only reason that I could think of that somebody would apply for this, unless you wanted to pay for your license in 3-month increments, there is no benefit to using this, because we would grant reciprocity to anyone from any state if they're AQB compliant and in good standing.
Thank you.
So that's the crux of why I was saying I don't think anyone will use it. Upon completion of all requirements, they'll be issued a regular credential, is what the last part says. The chief legal counsel was adamant that we had to have this in the event that Tennessee created requirements that were greater than other states.
Sure.
So, and an applicant who would have to prove that they're a military person or military spouse under this provision. Create a form for that.
Good.
Okay.
Any other changes to the rules that we discussed at our last meeting?
No other changes.
Oh, let's revisit where we are in this process. So we have to pass new rules in order to meet the new requirements coming down 1/1/15.
Right.
And this commission has talked about these new rules, and now you have once again looked at a draft of the new rules. Ms. Avers, is it appropriate at this time that we give notice to the public that we're going to have a rulemaking hearing?
Yes, there was, on the director's report, I had 3 things that I wanted to make sure I had commission's approval on, because it makes it so much easier at a rulemaking hearing when the public is going to be weighing in on proposals if the commission's already on the same page with those ideas. Specifically,
But let's be clear, not that the commission has made up its mind, but just that the commission is aware that these rules are
Right.
what they are, correct?
Right, I mean, ultimately, you'll vote on the rules at the rulemaking hearing, but if there's no changes, I would hope that the commission is either for the provisions of the rules or against it, and we just eliminate it now.
Right.
As opposed to going through a rulemaking hearing and finding out later that you're against some provision of this. The areas that I identified as the commission may need to take a close look at is the background criteria that would disqualify an applicant, defining continuing education for out-of-state reciprocal applicants.
Okay, I'm sorry, go slow. Disqualifying criteria?
Yep.
All right, that was one. What was the next item?
Defining the continuing education requirements for out-of-state applicants or licenses. all states are now reciprocal. So we have reciprocity with every state, territory in the United States. We just have different agreements as to how we'll handle their continuing education. I think we should handle it the same way for every state.
Well, and wouldn't it make sense that every state should be equivalent to what we require our people in state?
The minimum requirements is 28 hours with at least one 7-hour use PAP per 2-year cycle. That's a minimum requirement, or 14 per year. There's a lot of different ways states interpret it. Like, many states allow 100% online education for continuing education. If we have a reciprocal agreement with that state, we allow them to use it. If we don't have an agreement with them, they have to do what Tennessee's requirements are for continuing education, which is 14 in classroom. So those are some of the nuances that we need to decide how we're going to proceed on the rules. If it's, every state should probably be on the same criteria. Like, if we were going to we shouldn't treat someone from Kentucky different than somebody we're going to treat the way we're going to treat an applicant from Iowa.
Right.
And then discuss the plan on distance education for qualifying and continuing education. That was the third point. In the rules that are proposed, per your request, I included the language that Dr. Barilla had written previously to meet the online distance education requirements. And these have even been gone over by the subcommittee, and we'd be on 100% compliance if we change this requirement. Many of the states surrounding us have this. Georgia, Kentucky, Alabama, they allow online education to be used for continuing education and online education to be used for qualifying education if the exam is proctored. And there's an proctor approval process. That's included in there. It's the parts that are written with black underline. That's all new. And it runs from pages 176 to 178. That's the distance education portion.
Does that mention the, is it IDEC? Is that meant?
Is required for any online education.
Are there any others? I've got 3 potentially changing things. Any others?
That's it.
Okay.
We'll have to do the AMC stuff too, but I haven't had enough time to, since that was released, to write, review it in close detail.
Commissioner Hall?
Did we already vote on this qualifying?
No.
Because I remember we came up one time before and everybody voted for it except.
That was a straw poll, if I'm not mistaken.
Yeah.
Okay.
And that was just, we won't officially vote, and I was going to open the floor up very briefly for this conversation. We won't officially vote on these new rules until we've had a public hearing and we've heard public commentary, and then we'll have conversation and then we'll vote. I would suspect that these 3 items will remain contentious throughout the entirety of our conversation. So I'm going to open it up and let each commissioner make a statement if they wish in regard to these, but that is my personal suspicion. So rather than us talk about these potentially contentious items, I think we ought to take a stab at what the straw poll results are, incorporate them, have our public meeting, and then let the vote go the way it goes. That's my personal opinion, and now I'd like to open it up and Commissioner Walton, if you'd like to start, I'd give you all each a chance to say a piece, and then we'll move on. So,
Where to start?
What's the first item, pardon me, Mr. Walton, but what's the first item you got written down there?
Disqualifying criteria for granting a license to whom?
Any initial applicant for registration, license, or certification. So that would be the reasons to deny. That's what that means.
And
Yeah.
this relates to the findings of the background check, I'm
Yes.
assuming?
Yes.
Background check and related questions, yes.
I'll be honest, I'm not real clear as to what the legislation, how it is worded now. I mean, that might be kind of a basis to start from.
Maybe, I think it'd be helpful, Ms. Avers, if you could summarize, if you could kind of summarize the viewpoints. You know, you have the federal recommended language, and then there are some problems with that. Can you give us a briefing on why this is a contentious issue? I guess that's the way to put it.
The bill that has been signed by the Senate and the House is on page 137 of your iPads.
137?
Yep.
So that's the state.
That's the state version of State of Tennessee's bill that is waiting for the governor's signature.
Background checks. Okay.
Nothing in there that I could determine would prohibit us from using the NMLS once we have that authorized through the SAFE Act. If that happens. I mean, if it doesn't happen, either way, we'd still meet compliance, because we'll just have to do it through the TBI. But either way, we've got qualifying language for the $171. Datum from the AQB exposure draft.
You're at 1255-01-09.
Yes.
Okay. Is this from the, didn't they recently revise?
February, they revised the AQB,
Okay, that's what I was thinking.
so this is taken directly from that.
Okay. And it's pretty explicit, isn't it?
We're gonna have to ask questions relating to all of this, and if somebody is found on a background check to have, I don't know, pled guilty to a felony in the last 5 years, they're gonna have to be denied.
Why is this contentious, do you think? What part of this might we find contentious?
It's not really contentious, it's just I may not have covered everything. I mean, I think I've gotten it pretty detailed, but if somebody applies and they have 6 DUIs, those are misdemeanors, do you deny them? How detailed do you want this to be?
This is, I mean, if this is the minimum AQB criteria, then this meets Fed, so, I mean, we're,
Well, could we put in a provision that that would allow for discussion if there was something questionable?
Yes, Part 3 already exists in our rules, but if you just turn to the next page, it says, an applicant denied a license or certificate shall be notified in writing by the commission of such denial and the reasons therefore. Such applicant may request an informal conference with the commission to reconsider such denial at its next scheduled meeting. Such request must be sent to the commission office within 30 days of the notice of denial. So that would be like an applicant conference where we put it up and had somebody talk to the commission, and you all have to decide whether we inappropriately denied them a license.
Commissioner Hall?
You know, one thing I see in here, I do not, nor do I presume to have a better answer. However, I can see one thing in here that could lead to a denial that could also result in a lawsuit. And this is under item D, like in Delta. And it says the applicant has failed to demonstrate character and general fitness, such as to command the confidence of the community and to warrant a determination that the appraiser will operate honestly, fairly, and ethically within the purpose of these criteria. I know some appraisers right now who are operating, which in my opinion is unethical. They're not honest, and I don't believe they should be practicing under their current mode of operation, which could be very contentious, it could be very argumentative, and it would be difficult to prove either way. And I can see some attorney taking this and arguing on one side, and then have somebody hire him, he'd jump on the other side and argue just as vehemently on that side. I don't have an answer. I'm just saying that there is a potential there. You know, what's that old term, moral turpitude, that we used to have in one of our professional organizations? I think they finally got rid of it because nobody knew what it really meant. And so
That's like the most difficult term in all of the legal world. It causes more problems than you could possibly imagine.
So consequently, I'm not suggesting a change. I'm not suggesting anything other than to make everyone aware that, in my humble opinion, you know, these words could potentially present a situation where we need to make a determination about someone.
Am I?
Sure, please.
If you believe there is someone practicing unethically or in a biased manner, then you should file a complaint with this office and then recuse from vote on the matter so that the other commission members can act like a jury and decide whether or not this appraiser should be continue to practice as an appraiser. This language is the section that I'm asking the commission to consider. If it needs to be shored up, that language that you read specifically was from the criteria. But if you have a better way to say it than the AQB came up with, or you want it more specific, saying, you know, any misdemeanor is enough to be denied an appraisal license. Okay, well, that's very specific, so.
And we, you know, like she said, we can work this language any way you guys feel appropriate. As have to read exactly like that, as long as, so it's something to think about if you can think of a different way to say it. And I also think that's why it's important that we have the Section 3 allowing people to I think a lot of boards have similar things like this. I know on a previous board that I was on, a lot of their stuff said may instead of shall, but people were also given the opportunity to come before the commission once a denial was made, and I think that solved a lot of the issues. And even then, they could bring counsel or whomever they needed to represent a lot of the wavering issues. So at least it's good that that's in there.
Only part 1 at the top, only part 1 is the shall denies. If they have had their license or certification revoked in any jurisdiction, that's a shall deny. If they have been convicted of a felony, That's a shall deny within 5 years. Only part 1 is shall deny. Part 2 is the commission may deny, not shall. You can, may deny means may approve. Yeah.
Just the exact wording, I mean, has
Yes.
this been altered at all? Have y'all
Um,
tweaked this, or?
It's pretty verbatim. I had to redo it to the state's formatting for the outline, but it's pretty verbatim.
I don't think that we veered too far. I think it's pretty.
Other comments from
Has-
commissioners?
Will the Attorney General look at this? Okay.
Absolutely.
Mr.
They
Chairman,
haven't looked at it yet?
Probably numerous times. Not yet.
This is considered a rough draft.
They would have to
Want to
wait
get it
until
right
after
before we issue
had
it for
filed
rulemaking.
notice and did the actual.
Opposed?
Okay. Commissioner Hall?
like I said before, I had no better way to offer to change it. And I think it's one thing we need to remember, and possibly I should have been aware of this before I started speaking originally, and that is these are people applying for a license or certification, not that they already have it. So, technically speaking, it'd be very difficult to prove somebody guilty of a rule of something they're not even a member of. So consequently, until they become licensed or certified, if they've made bad appraisals in the past, it's going to be difficult to deny them because technically speaking, there were no rules. This was brought to my attention by a previous attorney representing this commission, Reed Brogdon, back when this commission first got started, and we tried to impose certain rules and regulations on people coming before this commission. And we were told until they actually become a member, there is no criteria until they become a member. So we have to accept what they give us at that point in time. Now that has changed some over the past few years because we do now have some criteria to deal with. But I think maybe we need to remember, what I should have remembered, is the fact that these are people applying for a license, so therefore, and until they actually have a license or a certification, then they really are not under our jurisdiction.
Thank you.
This section is on applications.
Exactly.
We have a section in our law, 6239-326, which is the parts that says the commission may suspend, revoke, or otherwise discipline appraisers, current appraisers, for violating the law or use patent.
I agree. In the past, I can recall one of the professional
Excuse me,
organizations.
Commissioner Hall.
Yes.
Let's move on,
Okay.
please.
No problem.
We were starting with Commissioner Walton. Do you have other comments about this set of rules at this time?
Yeah, just briefly, I think relating to the entire rulemaking process, it's very difficult to conceive of what might be facing the commission in the future, different cases coming before, and I think it's good to keep that in mind in making the rules, and we don't want to make them so specific that we handcuff the commission into acting or not acting. We want to have allowances for the commission to have discretion in cases that come before the commission. So, granted, this rule here, I mean, it addresses character. That's a very hard thing for the commission to judge with limited resources and not knowing a lot of the applications that come before us. But I think it's good to have a provision in there for it. Would you like me to move on to another topic, or we're just going to go through one topic every?
Well, let's address all of the topics within these proposed rules,
Okay.
and then we'll move on to the next commissioner.
As far as defining continuing education for out-of-state licensees, I think I think it had been mentioned earlier that we need to have more of a uniform approach. I would totally agree with that, but I think also we're kind of faced with what do we think is best, as opposed to what's good enough type of a scenario for continuing education. And I think there's a sense of inevitability for distance education. If it's not approved by this commission, it's going to be approved by a commission in the future. Do I think all online education is best? No. But I think, again, I think it's an inevitable thing coming forward. And if we don't go ahead and get on board, then at some point in the future, a future commission will have to get on board to be in compliance with the AQB and ASB, and to try and unify things in dealing with other states. And that's just my viewpoint.
Thank you. Thank you. Very considered. Commissioner Collinsworth.
I don't have a lot to say in regards to specifics, just overall, the three of them together. I think what Ms. Avers has prepared so far, putting in the minimum information that she's put in there that seems to be required. I know I don't want to be the one to try to reword some of this. I think it would be a good idea for us to let the Attorney Generals decide if there's any other legal terminology that needs to be changed about this once it gets to that point. And I think Mr. Walton may have missed our meeting where we discussed the continuing and qualifying education at length quite a bit. I think you may have missed that one, but we did go back and forth about it quite a bit in determining that to get to this point. So, going forward, I think we should, in my opinion, I think we should probably accept and move on with this part to get it to the rulemaking. Again, I know I don't want to be the one to try to reword any of this, and I think she's put in the minimum that's required to put in here as far as terminology goes. That's my opinion on it.
Thank you. Thank you. Commissioner Hall.
I've already voiced my opinion on the, but I agree with both my fellow commissioners that I think Ms. Avers has done an excellent job of preparing this. And at this point in time, if it meets all the legal requirements, I, for one, would not begin to try to reword action. As far as education is concerned, I have no trouble with continuing education being online. I do have trouble with all the qualifying education being online, but that's just my opinion.
Else?
No, sir.
Okay. Thank you for your opinion. That's very helpful. Commissioner Stanifer.
With regard to the background check, I would defer that to the legal side of this. I'm sure Keeling and the appropriate attorneys here will look that over thoroughly before it's in a final document or even a near final document. The continuing education requirement and the distance education requirement, it's my understanding we're going to have a public hearing that will address that and seek public input with regard to, I guess the real issue is the distance education.
Yes, once the commission gives us approval to move forward with this on rulemaking, I plan to send out a survey to the licensees and a notice on Notify, informing them that there's going to be a rulemaking hearing on these specific topics and to weigh in by either attending or writing your response in to the specific covered topics. That should get us enough of a response, I think. We have worked very diligently to get everyone signed up on the Notify system.
I would urge that we not predetermine something until after we've had the public input, particularly with regard to that issue. That's all I've got.
Thank you, Commissioner Stanifer. Well, I think I'm hearing somewhat of a consensus here, and the consensus that I hear is let's get this set of rules out there and get it exposed for public comment and begin the formal process of establishing these new rules. perhaps my fellow commissioners could signal whether I've heard you correctly by making a motion. Or perhaps not. And I'm looking for a motion so that we authorize Ms. Avers to go ahead and begin the formal process of this rule.
So moved.
Second.
We have a motion and a second. Motion was by Commissioner Stanford, second by Commissioner Hall. Is there further discussion? Hearing none. All in favor, say aye.
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 Any opposed? Hearing none, the motion passes. So we will direct you then to go ahead and move forward with this set of rules. Do you have any other items from the director's report, Ms. Avers?
No additional no additional discussion on the director's report.
Okay. All right. We have not had our 1 o'clock experience interviews, and I believe that's the next item on the agenda. So let's move on if everybody's prepared. And with noted timeliness, I think we have a new legal attendee, do we not, Ms. Baird?
We do. This is Adrian Chick. He's the new litigation attorney.
Sorry? You're not,
Go ahead, Adrian.
Adrian Chick.
okay.
I've been with the department about 7.5 years. I've been doing litigation for the funeral board, cemeteries, burial services, and a few others. So this is a little bit of a change that I'm excited about, and it's good to meet you.
I'm sorry, I apologize, but what was your last name again?
Chick, C-H-I-C-K.
Thank you.
I've been called Chick and Click and various other things, but either one's okay.
I think you'll find the appraiser board to be a little bit more lively, perhaps, than your previous.
Yes. There's always room for that little pun. It's good to meet you. Good to meet you.
Thank you, sir. While you're here, Mr. Chick, is there, can you give us a progress report on the cases that we have cooking?
Well, so far, we've got one case that Mr. Joseph had McSpadden, and
No names.
No names. Yeah, we're all
we've
very
got-
sanitized here.
We've got
so.
a formal that is going to be set probably July, based on the conversation with the reviewer and his schedule. So that's in the works right now to be scheduled. And
How many cases, how many hearings at this point are in process?
right now, I believe there's approximately 4 that that we know for sure need to go.
That sounds about right.
So.
Okay, so there's 4. We got 1 potentially in July, and do you anticipate that we could hear the other ones, say, by the fall?
I think so. Does the board meet fairly
Monthly?
pretty much every month?
Yes, sir.
I believe that's reasonable.
Okay.
I believe it is.
Okay, good. Well, the reason I'm asking, we're audited by the feds, and that comes in January.
Okay.
And no pressure or
I get
anything,
your
but
point.
yeah, okay. We got to clear these babies out to make
I
us
understand.
make us look good. So
Okay. I'll make that happen.
okay, all right.
And I fully count on Ms. Avers to crack the whip to keep me on it.
Don't say it if you don't mean it.
All right.
Thank you, Mr. Chick.
Thank you.
Thanks, sir.
Thank you.
Look
Welcome
forward to
aboard.
working with you.
Thank you.
Did any other commissioners have questions of Mr. Chick? I'm sorry.
No.
No? Okay. All right. Thank you, sir. All right, Ms. Baird, we are ready for your presentation of the legal report. And briefly, though, did the rules that we approved in 2012, are they now officially approved by the AG's office?
Well, they are gone and out of my hands. The AG, I had already sent the language that I talked to you guys about to the AG prior to the meeting
Right.
last month
Right?
to make sure that if you guys approved it, it would already be approved by the AG's office. That way we wouldn't have to go through another step. So I talked with the AG's office about that. The only thing that was left to include on there was the final roll call vote. I ended up having to That was the only thing that was missing. So I basically just attached the roll call vote off. So we're just waiting. I don't anticipate having any more issues though.
What is it? What do we get back the rules and they're stamped by the AG's office approved, or what?
Pretty much.
That's what it takes?
Yeah.
Okay.
And it's gone to
Has to go.
the Secretary of State's for 90 days.
Okay. So when,
Even really, if they're good, you still kind of have to wait 90 days for the Secretary. It's just the process. Everybody has to wait that long.
when will the 90 days be up?
I don't know an exact
Thank you. I'm
date,
aware of the
but
definition of 90 days. I appreciate that.
I don't know an exact date. I don't have an exact date.
Okay.
I
All
can
right.
have that information probably at the next meeting, though.
That'd be helpful.
And I
Yeah.
wasn't saying that to be snarky. I don't want you to think that's what I was doing. I just don't have an exact date. I know that you know what 90
Probably
days
60
mean.
days at that point, Mr. Green.
Yes, thank you, thank you.
Mr. Chair, can we take a 5-minute break to use the ladies' room? And-
Yeah, although we'll use the men's room, but that's fine. Yeah, we'll take a 5-minute break. Thank you.
Mike, it's like when you have an appraisal that's due in 60 days.
Just returned from our lunch break, and we are on the agenda. We're going to go to the last of the experience interviews. Mr. Tim Walton interviewed Mr. Adam Brabson, who was applying to upgrade from trainee to certified residential. He has not yet taken his exam. Mr. Walton, what say you?
Interviewed Adam Brabson and reviewing his reports and also interviewing him in person. Demonstrated very knowledgeable appraisal technique, and I would recommend him for certified residential pending the outcome of his exam.
Thank you. Commissioners have heard the recommendation. Is there a motion?
So moved.
Second.
Motion from Commissioner Stanifer, second from Commissioner Hall. Is there any other discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes. All right, final item on the agenda, pending any new business, is the legal report. Appearing before us is Ms. Keeling. What is your last name now? Does it remain Baird?
No, it's Gamber.
Gamber?
Yep.
How do you spell that?
Gamber.
Okay, well, thank you. I trust that we'll get your name badge reworked there. All right, Mrs. Gamber, please proceed.
Okay. Item number 1, 2013-018641. Complaint was filed by a consumer and alleged respondent's value opinion was inflated by about 90% in his report. The comparable sales used were not in the area of the property appraised, and in one case, even in another city. The complaint alleged that the appraiser was a trainee and the signer of the appraisal is not knowledgeable with the property in the area of the appraisal. Respondent provided a response to the complaint stating that the appraisal was based on the best available data at the time of the appraisal, and the complaint does not tell the complete story. Respondent stated that the complaint alleges he used data from different cities, and this is correct, but they were in the same market area, which is a major tourist area. Respondent maintains he did not violate USPAP in any way. The reviewer conclusions are listed there, and there's also the respondent's response to those conclusions, which is pretty lengthy, so I'm not going to read that. You guys can just review, and then when you're ready, just let me know.
Let me poll the commission here for a second. Does the commission need to read these, or have you already reviewed them previously? Is there anyone that needs time to read these? Commissioner Hall and Stanifer, how about you guys? Do you need time, or can we move on to the respondent's response? Or do you want to move on to the to legal's conclusion? Gentlemen?
I'd like to look through the response. Yeah, the respondent's response quickly.
Okay, just let me know when you've reviewed it. Okay, if commissioners have completed their review, legal, would you like to finish your presentation on this case?
Yes. On the reasoning and recommendation, cited on this one to just defer to the commission for discussion and a recommendation on this matter.
Thank you. Really going out on a limb on this, are you?
You don't seem like you're very excited about that, but I think it's probably best in this situation.
No problem. Commissioner Hall, would you like to start?
Yes. Is this an apartment complex that we're talking about, or exactly what is it?
It's not an apartment complex. It's more of, it's like a shop, like a retail shop.
Condo in here at one point.
And it mentions buildings 3, 4.
It's not apartments.
So I couldn't figure what kind of property we were talking about here.
It's like a string of retail shops. That was my impression.
Yeah, that's a fair analogy.
Building 3 is rented solely as apartment space. Building
I think in this situation, it's not, they're not apartment spaces. Perhaps they're being rented as something like that, but it's not like an apartment building. It is like a string of,
Sounds like a mixed use.
right.
Would anyone like to either offer up discussion or make a motion of some sort?
What's throwing me off in the response from the respondent is there's a statement in there that says the owner has 100% occupancy. Is this an owner-related entity that he's renting it to himself, or I'm
I think he's saying that the property's full. I think that's all he's saying.
okay? All right, so it's 100%. It's not vacant. There's no vacancy.
That's what I get. I can't tell you that. I don't know the deed.
Maybe you're right.
It is a little confusing, but that's what I took out of it too when he's talking about 100% occupancy and then discusses the price per square foot
Yeah.
for the rent is below market. Kind of difficult to parse any of this out without seeing. We're reading a reviewer's comments. We're reading some respondent comments.
Right.
We don't have a clear idea of what the property was.
Well, based on the
Or-
information presented, if it's an income-producing property, it should have been lease fee estate.
I would disagree. You know, I'll go first. How about that? I'll start. I tend to agree
Month to month.
with every comment that the respondent offered. Pretty much every one of them across the board. If a property's rented month to month, there is no long-term income stream that you can value and call it leased fee. Because how would you do that? How would you stamp a value on something that in 40 days, the income's totally different?
Right, but let me ask you a question. When was that value given? What's the date called? The effective date of the report. On the effective date of the report, did the owner have full unencumbered fee simple ownership of that property if it's month to?
My answer would be he would within 30 days.
But on the effective date of the report, would he have fee simple ownership?
You make a good point, but
I can see him using market rates. I agree with you on that. Maybe he would use market rates, but I still think it should be a lease fee.
all right, let me provide a converse argument.
Sure.
As an investor, how much weight will you put in the income stream that these month-to-month leases generate?
Well, no, that's where you're missing me. I agree with you. He could use market rates to determine it. So fee simple and lease fee should be the same.
All right, but if we call it leased fee, if I'm buying this thing and you're selling me a value that was generated as leased fee, and I get in here 6 months later, let's say I'm out of town and I close 6 months later, and I'm looking at the income stream and it's a third what it was on the date of your appraisal, I'm going to have some serious questions for you as an appraiser. So I'll just finish and then I'll go to the next commissioners. I can't find an argument in this case.
I'm like you, other than him calling it fee simple. I think his responses were pretty good.
And the only thing that gives me some heartburn is the fact that I can't discern from the reviewer's comments or the respondent's comments whether the income was processed properly, the income approach, I should say, because I can't tell if he like forgot to put in some expense categories or what. But other than that, I have a hard time with anything other than a potential letter of caution. So, and that's, I'll be quiet.
I think to answer your question on that, based on the respondent's response, he said it was just a wash regarding the CAM charges and then deducting them. So he really didn't even put them in because, in his opinion, they would have been a wash. So,
Second to the last question, or second to the last sentence, the respondent
include all
says
expenses.
he did not include all expenses.
Yeah, I think that's what he's referring to, is the CAM charges.
Commissioner Hall?
Sure.
I agree, I have no problem with fee simple. Because on a month-to-month basis, it can change. I know there's a lot of opinions floating around as to whether that's true. I've met some appraisers who said if you appraise an apartment, each one's on a month-to-month basis, then it's got to be the lease fee. I disagree. If you got a sales history or a rental history on the property, I have no problem with a fee simple. The second point I'd make is that under Tennessee law, the date does not necessarily indicate what the value should be, i.e., like in a hotel or a motel. The law says it has to be valued as of January 1. So technically speaking, if you're going to appraise that property as of that date, you would have to consider the income expenses as of that date, which is not recognized. So I think you consider the date, but you have to consider other things besides that as to what contributes to the value of the property. But I agree with both of you gentlemen. I don't see anything in here that would warrant anything other than just be careful.
Thank you. Commissioner Stanifer?
I guess down at the recommendation of the reviewer is to defer to the commission recommendation?
Yes.
It's not the reviewer's recommendation,
It's
that
your-
was legal's recommendation to you, as to whatever the commission decides.
Recommendation. They never make recommendations in these situations.
Have a tentative idea what you might recommend on this, or?
I was just gonna leave it up to you guys on this one.
As is your prerogative. Commissioner Stanifer, do you have further comments or questions?
I do not, other than it's difficult with, while there is quite a bit of information here, it's difficult to come up with a recommendation based on what we have here, in my view.
Thank you.
I've got a quick question. All of you guys are CGs. I'm a CR. You're a CR. From a residential perspective in dealing with income, typically, you'll analyze the contract rent, but that's not always market rent. Then you would develop your income approach based on the market rents that you develop. So I'm not sure where the month-to-month lease, that could be contract rent, it may not be. But wouldn't you develop a market rent and then value the leased fee?
No, not necessarily.
complainant and the reviewer both indicated that this property was overvalued. The complainant said by 90%, and the reviewer went on to explain that analyze certain aspects of the rental or the income of the property, it was overvalued. I don't have a lot of expertise in this. I'm a residential appraiser also, and so what I would do in a residential income property is not necessarily what for retail. I really was not sure where to go with that, so I didn't have any advice to Keeling on it either.
I just don't know if there's enough information here to be able to, you know, because back to the lease fee estate, you know, if there were non-market lease terms, FIREA requires that those be discussed in the report, over and above fee simple.
Well, and I think it gets murkier because the respondent states that this, and once again, he doesn't say this was a bank-ordered appraisal. Are you able to, okay, a bank ordered this appraisal, so I think we can then move on to the fact that the bank ordered the fee simple value. And if that's the case, well, but in a previous commission meeting, we talked about the fact that the bank ordered, you must do what your client requests you to do, and the bank ordered fee simple.
But you must also be aware, because it was for a bank, what the interagency guidelines and FIREA require. And they require you've got to consider non-market lease terms in the report.
My feeling is that this appraiser did, but since they were month to month, that they were not material.
Use the market rates, yeah.
Correct. And I could almost put my finger on what this situation is, but I'm only suspecting. So, I mean, not who so much as what
The situation
the
itself.
complainant's, yes,
Yeah.
the complainant's purpose for this complaint, what have you. All right, well, moving along, Commissioner Walton, did you have any other comments?
No, that's it.
Okay. Commissioner Hall? No. All right, is there a motion regarding this matter? That could range, remember, this is probable cause, so your motion could range anything from complete dismissal to suspension or revocation, or something in between, such as education and a fine. So,
Or a letter of
can I-
warning or caution or anything like that too.
correct.
Is there a specific course on the income approach?
Residential and commercial have different courses. There are two,
30-hour total in there.
it's 60 hours per income.
60 now.
For non-residential.
That's right. They increased it a few years back, doubled the size of
Yeah,
it.
so there's two parts. Most course providers split that 60 hours into two parts and hold it that way. There's really only one that's approved in Tennessee. Also have some other courses that can be used as active hours, like they have an advanced income class, or proof for qualifying education that are income type courses. Like would all
How about someone makes a motion that we get out there for discussion?
I'll make a motion that we send this person a letter of caution.
Is there a second?
Second.
All right, motion to send a letter of caution by Commissioner Hall, second by Commissioner Walton. Further discussion?
disapprove, what would we be cautioning them? Because we're going to need to be specific.
Caution them to apply the income approach properly, I assume, because once again, I can't find enough meat in this thing to really,
I don't think we've got enough data.
to make a recommendation one way or the other. I just don't feel like I know enough about it to make a recommendation one way or the other as far as, quote, fines, education, or anything else. And that's the reason I'm saying, without any more information that we've got, and there's a lot of questions raised, there's a lot of answers that were given, and
More information we could provide you at a future meeting that would be enough to clarify it for you. I don't want you to make a recommendation that you're not confident in. If this isn't enough,
I mean,
Well,
if there,
give us direction.
If you provide us more information, I mean, we've got to be careful as far as
if there's something
getting into evidence that could be used at a hearing in the future. I would say we could fine tune the letter of caution down to some of the things that he does admit to in his response, such as the CAM charges and not including all of the expenses in the least fee value estimate. Those are things that, I mean, how are you going to properly develop that approach if you don't include all the expenses?
Point well taken. Would you like to withdraw your second and withdraw your motion and revise it to make it more explicit?
I have no problem. I withdraw.
I withdraw.
And would you like to restate it then, Commissioner Hall?
I prefer someone else do it because, once again, I don't.
All right, I'll make the motion that we issue a letter of caution to the respondent regarding his due diligence in developing the income approach and including all the information needed, such as CAM charges and all the expenses in developing that approach.
Okay, we have a motion by Commissioner Walton. Is there a second?
I'll second it.
Second by Commissioner Hall. Is there further discussion? Hearing none. All those in favor say aye.
Aye.
Aye. Any opposed? None opposed. Motion,
Nay.
we do have one opposed. One opposed. Motion still carries on a vote of 4-5. So, letter of caution. All right, next case, please.
on item number 2013019101, I know in the legal report that you have, there's a lot of discussion about this one, but after the legal report was concluded, I received knowledge that some things, I think it was just a mistake, basically. Whoever filed the
What was the
complaint-
mistake?
Whoever filed the complaint against this respondent never meant to file a complaint against this respondent. He was trying to file something else. Somehow this respondent's name mistakenly got included in the complaint, so we went ahead and did a review, and then in hindsight, the complainant never meant to file the complaint against this respondent, and it was an attorney. He did write a letter saying that he did never mean to file a complaint against this person. So now my recommendation is just to close this matter because it shouldn't have gone through this process in the first place.
So moved.
Second.
Motion by Commissioner Hall, second by Commissioner Standifer. Is there further discussion? I'll offer some. What was the cost of having this reviewed? In round numbers? I don't want you to violate any confidentiality provisions here or anything, but
$1,200, I think.
well, I just find it very, very troublesome that, when did it come to light that this attorney accidentally submitted a complaint?
First item and the second item are related items, and they turned in. I meant to complain against one of them, but he had made allegations against.
Basically, I think what happened was he included information concerning the person in matter number 2 on a former appraisal that he had done that was several years prior to. It wasn't trying to complain against the first person. I think somehow when information between the bank and all of that was going back and forth, somehow just as a prior appraisal, I suppose the respondent in matter number 2's name got tossed in there because he had done a former appraisal on the same property.
Are there any takeaways for us on this? Is there a potential takeaway that we ask the complainant something before we spend the $1,200? I don't know. I'm just saying, gosh, what a whole bunch of work and a whole bunch of aggravation for the respondent just to get to this point. Good heavens. I mean, is there maybe an intermediate step in which someone from our staff calls the complainant and say, look, we've got this. We're going to process it. Are you aware of this? I don't know. Other commissioners, do you have comments?
Send them letters acknowledging the complaint and identifying who the respondents are in the matter, and he didn't respond on the initial outset that, oh no, I didn't take it back. So we do read questions, so-and-so has filed a complaint against you, this is what they're saying. We read those, but it was just a long, detailed attorney's letter that included more than one person, and it didn't specifically say go there.
Any further discussion? All right, hearing none. Well, there's a motion on the table to dismiss and a second. All those in favor say aye.
Aye.
Any opposed? None. Motion passes. Third item, please.
Item number 3, 2013023001. This complaint was filed according to a letter that was sent by the FHA of HUD's removal with education sanction against the respondent for violations of FHA guidelines and USPAP. Respondent failed to comply with appropriate assignment, scope of work, and an FHA appraisal assignment by including excess land in the value opinion. In addition, respondent failed to provide rationale for using comparable cells more than 11 miles from the subject and were not similar in acreage. Respondent sent a response to the complaint stating the subject property did exceed the predominant one-unit housing pricing due to the subject's larger gross living area and size of site. The property is the upper end of its market. The research conducted on the original report and the additional research submitted to FHA shows that the subject's market area accepts a wide variance in lot sizes. It was not known if any of the subject's land could be subdivided for lots. A perk test by the governing agency would have to be completed. Respondent stated that the subject property was not overvalued, and in respondent's opinion, a residence with 11.2 acres could be readily marketed. And he also provided exhibits. The reviewer conclusions are listed there, along with another somewhat lengthy response to those conclusions. If you guys need to take time to read that.
Please. Right, looks like we've reviewed it. Would you like to continue?
Yes. The reviewer indicated lack of reasoning and support for opinions in the respondent's appraisal. Respondent has been a certified residential appraiser for approximately 4 years with no prior disciplinary action. As such, council recommends the authorization of a letter of instruction relating to USPAP reporting requirements.
Okay, thank you. You've heard council's recommendation for a letter of instruction relating to USPAP. Is there a motion?
I'll make a motion to accept.
Second.
Motion to accept by Commissioner Hall, a second by Commissioner Standifer. Further discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? Hearing none, the motion passes. But before we move on, Ms. Baird, at the bottom of page 6, could you please read the last 3 sentences?
There was a large variance in the, is that what you're talking about?
Oh, my page 6 is, last 3 sentences begin with, "This could not be avoided."
This could not be avoided. Most of the emphasis was placed on closed sales 1 and 2 due to their most similar above grade, so loving spaces and actual ages versus the subject property. I'm sorry, that sounds really inappropriate, and that was supposed to say living.
I think living was supposed to have been
I
the
apologize.
appropriate word.
I'm thinking that. I just wanted to make sure that there wasn't some new residential.
You can use that though later. I mean, like if you just feel like it's appropriate to put in your report.
I don't do residential work, and I didn't know. I thought maybe it was sort of like outdoor
Yeah,
living.
I apologize. That was my mistake.
I don't know, that sounds commercial to me.
Yeah.
Does it? Above grade loving.
It's just
There should have been a
awful,
positive
really.
adjustment for that, don't you think?
I would think so.
Okay.
Well, depending. Okay, thank
I
you.
apologize.
Oh, no need, no need.
I won't make that mistake again.
I just wanted to clarify. I didn't know. Okay. Item 4.
Item 4, 2013024311. This complaint was filed by an appraisal management company and alleged violations of USPAP and other applicable professional standards. The complaint listed several USPAP sections that complainant AMC alleged respondent violated. Respondent sent a response stating their appraisal was for a reverse mortgage loan so the family could keep their mother's property. The cost data was Marshall and Swift. Land sales were used from and supported by county land sales. Income data was not applicable. This is a small rural county with limited information and sales. There is no contract for sale on the subject. Respondent stated that she tried to meet company requests and changes. She was having some trouble with software and emailing the report. She also enclosed a medical statement from her doctor due to illness and indicated in her letter that she wants to make her license inactive as she can no longer handle the stress of appraising. Respondent has not placed her license into inactive status at this time. The reviewer's conclusions are listed there. The respondent was also given the opportunity to respond to those conclusions. However, no response was received by this office. So, if you need to take a minute to look over those conclusions.
Would someone like to make a motion? Well, actually, we need to hear legal's recommendation. Let's go ahead and get your recommendation.
Okay. The reviewer found the quality of respondent's work to be deficient in compliance with USPAP. Respondent's been a certified residential appraiser for approximately 10 years with 1 prior disciplinary action against her, and that's listed above there. As such, council recommends the authorization of a consent order for voluntary surrender, as the respondent indicated she wished to make her license inactive, and she has a scheduled expiration date on the license of May 31st, 2014. Such terms are to be settled by consent order or formal hearing.
Do I hear a motion?
So moved.
Second.
Motion by Commissioner Standifer, second by Commissioner Hall to accept legal's recommendation. Is there further discussion?
Quick question, Ms. Baird?
Huh?
Quick question. I assume her file will be marked, and if for any reason she wants to reapply, then at that point in time, this matter could be brought back.
If you want to flag the file, we can always do that.
an applicant has a voluntary surrender disciplinary matter, any reapplication would have to consider that.
Any further discussion? All right, hearing none, all those in favor say aye.
Aye.
Any opposed? None opposed, motion passes. Item number 5.
Item 5, 2014003791. This complaint was filed by the administrative staff, Tennessee Real Estate Appraiser Commission, for failure to provide a valid surety bond. Notice of cancellation of the bond was effective February 21st, 2014. Subsequently, respondent provided a valid surety bond to this office on March 1st, 2014. Since proof of a valid surety bond was provided to this office, council recommends this matter be closed with no further action.
Do I hear a motion?
So move.
Second.
Move to accept in a second. Motion was by Commissioner Hall, second was by Commissioner Collinsworth. Any further discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? None opposed, motion passes. Item 6, please.
Item 6, 2013011711. This item is being represented from the January 2014 commission meeting. I went ahead and put in the information that you see there that follows that first sentence was what was presented to the commission in January. I just wanted to include all of that so that you guys had that in front of you. And I also included the recommendation. The council voted to approve my recommendation at that time, which was a civil penalty for $500, as well as a 15-hour advanced residential applications and case studies course. So that was approved in January. The issue was in the January commission meeting legal report, it stated that respondent failed to provide a response to the reviewer's conclusions. However, respondent did provide a response that was not received until the date of the commission meeting, so it wasn't noted until after the fact. In addition to providing a response, respondent requested an informal conference with Executive Director Avers, myself, which was held on March 17th, 2014. During this conference, respondents' responses to the reviewer's conclusions were discussed, and it was found there were 2 major issues with the report. Respondent did not seem to fully understand seller concessions, and there was not enough detail in the reconciliation. Respondent was able to explain most of what was at issue in the review in a manner that was satisfactory to Executive Director Avers and myself. Respondent seemed to have a good working knowledge of the details that make up an effective appraisal report. After meeting with respondent, it is the recommendation of council that commission authorize a letter of warning regarding seller concessions and reconciliation in lieu of the previous authorized civil penalty and continuing education course. In addition, it is the recommendation of council that while we cannot mandate in the letter of warning, the commission recommend a 15-hour market analysis or report writing course to respondent to assist in his understanding of the inconsistencies related to this appraisal.
Okay, so we've heard council's revised recommendation, which is a 15-hour market analysis or report writing course, in addition to a letter of warning. Is there a motion?
So moved.
Second.
Okay, so we have a motion to accept and a second. The original motion was by Commissioner Walton. The second was by Commissioner Stanifer. Is there discussion? Hearing none. Oh, is there discussion?
So you're saying that in your letter of warning, though, you cannot make them take you can't add that because it's just a letter of
Oh,
warning.
yeah, because it's not formal disciplinary action.
Right.
We can't mandate that he take it. You can make the recommendation if you choose to do so, but we can't require it.
So,
I think he will take it. It's just a matter of whether or not it rises up to get the certificates and.
so you can recommend it in the letter
Right.
that he take it. Okay. Okay.
Is that, I guess my comment would be, is that, and I really thank you for that clarification, because I didn't get that. Thank you. Is that sufficient, y'all?
That's why I wanted to stop and discuss this, because
I mean, in light, here we got a complaint. We had it reviewed at some expense. Appraiser had a chance to respond to the review and didn't take didn't avail themselves until the last minute, so we didn't hear it. So we voted on it, we discussed it, and we voted on it, and now,
I just wonder if it's sufficient to go from a $500 fine and a 15-hour class down to a letter of warning
I
and
will
a
say,
suggestion.
not that this has anything to do with your all's recommendation, but just so it's known, he did actually respond. I think the day of the commission meeting was the last day he had to respond, and up until that point I had not received it, but I did get it that day, which is why I felt like it was necessary to come back and say it's not true that he didn't respond, because he did. I just wanted to make sure I was being fair. So
Waited till the last day to respond.
the
That's correct.
last day. Well, there is a motion on the floor in a second. Any further discussion? All right, hearing none. All those in favor say aye.
Aye.
Any opposed?
Nay.
I'm opposed as well, so motion still passes. Okay, that was item number 6. Item number 7, please.
Item 7, 2014003781. Complaint was filed by the administrative staff of the Tennessee Real Estate Appraiser Commission for failure to provide a valid surety bond. Notice of cancellation of the bond was effective February 14th, 2014. This office has evidence via certified mail return receipt card that respondent received notice of the cancellation from this office. The return receipt card was signed by respondent on March 6, 2014. However, respondent failed to provide a valid surety bond subsequent to being put on notice. Therefore, counsel recommends the authorization of a consent order for the voluntary surrender of respondent's appraisal management company registration effective immediately upon execution of the consent order, such terms to be settled by consent order or formal hearing.
So moved.
Second.
All right, so we have a motion to accept the consent order, motion to accept legal's recommendation of a consent order by Commissioner Hall and a second by Commissioner Walton. I'll start discussion. Do we want this to be a voluntary surrender, or why aren't we just revoking their registration?
I don't know, I think that I always start out with voluntary surrender, but I suppose that you want it to be worded revocation.
If they agreed to it by consent order, they're voluntarily giving it up. If it's revoked, generally that happens through the formal hearing process, and that would be what we'd be seeking if they didn't agree to this.
I see.
It sort of ends up being the same thing.
Right.
You
So
know,
I'm
you
assuming
either-
by them signing, it's more or less understood that it's agreed
It's agreed.
and not sending it in.
Okay, I'm with you. All right, I have no other comments. Any other discussion? Hearing none, all in favor say aye.
Aye.
Any opposed? None opposed, motion passes. Item 8, please.
Last item, 2014000741. This complaint was filed by an appraiser alleging that respondent removed his name from the AMC appraiser panel. Complainant alleged respondent's numerous phone calls were what was keeping him from completing the assigned appraisal report. Respondent filed a response stating complainant was a member of respondent's panel from November 24th, 2009 to January 17th, 2014, during which time he received 3 assignments. For all 3 assignments, complainant failed to meet the conditions of the assignment, including failing to meet due dates, failing to communicate the issues properly, and placing inappropriate comments within the reports. Respondent stated it has complied with all applicable regulations of an AMC in Tennessee. The complainant was removed from the panel for a number of reasons, primarily related to the 3rd assignment. On January 17, 2014, respondent contacted complainant to discuss the potential removal from the panel. Following the phone call on January 17, 2014, respondent sent a notification of removal and opportunity to respond to the complainant. Respondent included an extensive timeline of events regarding its communication with complainant on the matter, as well as evidence of the notification sent to complainant regarding removal from the panel in January of 2014. Sufficient information was provided to show that there were no violations on the part of respondent regarding its removing complainant from the panel. Complainant failed to provide sufficient proof of a violation on the part of respondent in this matter. Therefore, counsel recommends this matter be closed with no further action.
So moved.
I have a motion from Commissioner Collinsworth. Is there a second?
Second.
Second from Commissioner Walton. Is there a discussion?
Would you mind explaining to me what you just read? I mean, I'm
Sure,
just
where
trying
should
to
I
figure,
start?
what does all of this mean? I mean, we got an AMC, we got an appraiser. The AMC removed the appraiser from the panel, the appraiser complained, and now we're gonna close. Well, what happened? I
The
mean,
complainant was complaining that he was removed from the appraiser panel without the proper steps
Notification.
that the AMC was supposed to go through in order to remove him.
Okay. I
However,
got
he
you.
didn't, the complainant didn't really provide much, if any, proof that there was, any violations on the part of the respondent, and then in turn, respondent sent in a great deal of information with the timeline of everything and the steps it had taken in order to do this properly. So that's why I suggested closing. Does that make more sense?
So the bottom line is, he's still off the panel, right?
Correct. Yes.
It would appear, yeah.
Okay, I'm just trying to understand.
Bottom line, he's off the panel, and there didn't seem to be enough evidence to pursue the AMC
Right.
for any wrongdoing.
Okay, just trying to understand.
Any other comments or discussion? Hearing none. All in favor, say aye.
Aye.
Any opposed? Hearing none, motion passes. Is there any new business? No? All right.
When is the meeting in San Francisco?
Begins on Friday.
Friday?
Friday at noon.
Okay, all right.
It's being held at the Sir Francis Drake on Union Square in San Francisco. We hope you'll join us.
I've been there.
Excellent. All right.
Been there, done that. Next question. Now, when is our next meeting?
It's in May.
When-
What's the
when-
date in May?
What date in
Ms.
May?
Amers?
Second Monday, I can't recall the date off the top of my head.
Possibly.
That sounds right.
Are you certain of
Be 2
that?
days
Because
away.
it's not always the second Monday.
Second Monday is
This
as
month, for
well.
example.
Barring any holiday, it's May 12th.
May 12th?
Yeah.
Isn't that also Mother's Day weekend? Mother's Day
Mother's
is
Day
usually
is
the
on the
10th.
11th.
On the
yes.
11th, okay.
I'm just saying.
Oh, okay. That's okay. Mr. Chairman Green and I have to discuss this matter.
Yes,
I'm
yes.
just trying to make sure our dates are, get our dates
Yes.
correct.
Yep. All right. All right. I think that concludes our meeting. There being no additional business, we stand adjourned.
Started raining. Yes, please.
I value my gonads too much.
Yeah. You guys would be the only two
Well, that's
on the